For two consecutive weeks in December 2024, hundreds of people gathered in front of the International Court of Justice, the world's top court, chanting slogans and sharing testimonies and stories of climate change and injustice. Individuals and communities from around the world, particularly those on the front lines of climate change impacts, came together to share their experiences and call for climate action, all while something historic was unfolding inside the court. You are listening to Climate Court Voices, a podcast where we speak with the individuals leading crucial climate lawsuits and championing environmental justice efforts worldwide. Two years ago, the ICJ was asked to issue an advisory opinion clarifying the obligations of states in respect of climate change. The case represents a watershed moment in the global struggle for climate justice, and the court's decision, expected on July 23rd, is poised to reshape the landscape of international climate action and to be cited in climate change-driven litigation around the world. Leading the ICJ's advisory opinion campaign was Vishal Prasad, a young climate activist from Fiji, one of 14 small island nations in the South Pacific Ocean. For Vishal, and countless others in the Pacific, climate change is a real and imminent threat, already eroding the very fabric of their existence.
In the Pacific, the problem of climate change has been labeled as the single greatest threat for Pacific Island countries. It's been recognized as such by all our Pacific leaders, and its impacts are as extremely significant, existential, very existential in nature. You have countries like Kiribati, Tuvalu, and the Marshall Islands that are facing existential threats to their country because of sea level rise. So they are facing the threat, the possibility, the reality of being completely inundated by sea level rise if we do not curb emissions, if we do not halt emissions. And then there are other instances. For example, I know in Fiji, I was able to visit one of the villages in Fiji that was the first to be relocated because of climate change. And this is a very sad experience to hear from the people that have been displaced, that have been forced to relocate, to hear how they've had to leave their ancestral burial grounds, how they've had to leave their ancestral homes where their grandparents and their parents were born, and how that land has been passed on to. We talk about this idea of land in the Pacific as being not just the physical land, but what it represents. It's this sense of identity, this sense of belonging, and it's also this connection to the past and to the future. And leaving that behind, many Pacific countries are facing this reality of forced relocation, and we're not even ready. We do not have funding for this. We're just finding our way through this. This is a completely new phenomenon that's never been experienced by Pacific peoples. And so to be able to navigate this is a huge challenge of it. And I think the region is doing immensely well in considering the circumstances relating to climate mobility. We're seeing immensely strong cyclones now becoming more and more frequent. So previously category 4, 5 cyclones, those that are branded hurricanes, used to be once in a decade kind of occurrence. Now they are happening almost every year. Every cyclone season you should prepare, and that's how the warnings go out, to prepare for at least one severe cyclone. We've had the second, actually the strongest cyclone to hit landfall in Fiji, tropical cyclone, was the strongest in the southern hemisphere at least, and it devastated a third of the country's GDP within a couple of hours that the cyclone was there. So the threat to all of these, the threat of climate change manifests in many ways, and you talk about how it's affecting variety of areas, essentially all areas of life in the Pacific. There is an discernible impact of climate change there. If you talk about oceans, if you talk about water safety, if you talk about gender, if you talk about relocation, migration, all of these issues has an element of how climate change is affecting. So it's affecting across sectors, across societies, and across everyone's lives in one way or the other. And that's why it's such an existential problem for the Pacific. But one other thing that our campaign that we wanted to address was this human rights dimension, a human rights impact of climate change. So people are at the center of being affected, and frontline communities, they and representatives of these communities are standing there having essentially all of their human rights violated because of climate change. Their right to life, the right to water, food, sanitation, self-determination, the ability to enjoy and practice their culture, traditions, all of these are being affected. And so there is a human rights cost to this, and human rights law provides remedies for that. But this was an attempt. We're also wanting to spotlight and put people at the center of this, that there are people suffering. It's a human toll, it's a human cost that's there as well, alongside all of these other impacts of climate change.
Vishal was a university student when in 2019 he joined a group of climate activists known as the Pacific Island Students Fighting Climate Change. Its young members believe that international law must serve as a compass for justice and accountability. It is them who we have to thank for bringing climate change to the ICJ. But getting there wasn't an easy task. The group's 27 members began a campaign to persuade the leaders of the Pacific Islands Forum to take the issue of climate change and human rights to the world's top court, and eventually joined forces with youth from Asia, Africa, Latin America, and Europe. 3 years later, their efforts paid out. In August 2022, during a leaders' meeting of the Pacific Island Forum, Vanuatu proposed seeking an advisory opinion from the ICJ on the responsibilities of states concerning climate change and human rights. This proposal received unanimous endorsement from all of the forum's 18 member countries. The next step was obtaining a resolution from the United Nations General Assembly, so the campaign shifted to New York. Here, the youth movement mobilized support from various sectors leading up to the vote at the UN. Vanuatu orchestrated a coalition of countries to spearhead negotiations, and on March 29, 2023, the General Assembly unanimously adopted a resolution requesting the ICJ to provide an advisory opinion on the matter. I asked Vishal to explain what makes an advisory opinion such a valuable legal instrument.
A couple of things. I think the first, an overarching theme on why the advisory opinion was chosen was because we wanted to push or explore all possible avenues to address the climate crisis. The ICJ's opinion would be crucial in guiding the world on what they need to be, what states need to do in order to address the problem of climate change. And so advisory opinions are not binding to parties to a conflict, to a contentious case, for example. They are advisory and apply to the whole world in that nature, and it's guidance to the whole world. And so we thought that is the most effective way to provide the whole world guidance on what needs to be done. There was a lot of passing the buck, exploiting loopholes, delay tactics, delayed promises that we saw at the negotiations. And so this way, definitively and concretely, we have a chance for the ICJ to settle what countries need to do. The second, I guess the second reason why this was taken was this is an attempt for the ICJ to kind of holistically look at what countries need to do. So far, climate action has been guided by the Paris Agreement and the UNFCCC, but via an advisory opinion, the ICJ has an opportunity to kind of integrate the different bodies of law that exist. So human rights law, for example, and I talked about this earlier, environment law. We've recently seen that the International Tribunal for the Law of the Sea talk about how the Law of the Sea Convention also relates to climate change. And then how customary international law also relates to climate change. So all of these bodies of law that have been sitting in silos have now a chance to be integrated and looked at more holistically to interpret what countries need to do to address climate change and advance climate justice. The ICJ is best placed to do that, and the advisory opinion one of the avenues to do that. So by holistically looking at all of international law, this would be groundbreaking and transformative, because you will be looking at climate action from a completely different angle, not just through the through one platform, through one avenue with the Paris Agreement, but across all of international law. And so that's the other reason why an advisory opinion was chosen, because of its potential to integrate international law and provide a concrete, definitive response and state obligations.
The ICJ held public oral hearings at the Peace Palace in The Hague last December. The proceedings saw record participation, with 96 states and 11 international organizations presenting arguments before the 15 judges. It was the first time that states like Barbados, Nepal, and the Cook Islands appeared in front of the court. The hearings were unlike any before them, deeply participatory, centered on the lived experiences of those most impacted by climate change, and informed by their expertise on climate solutions. Indigenous peoples, frontline communities, and civil society groups played a central role, bringing powerful testimony, legal insights, and moral clarity to the court. Vishal and many of his fellow climate and indigenous activists got their moment too.
It really was a lot of emotions at that time, and building up to that as well. It was the culmination of 5 years of hard work, of campaigning and working to get to that place. And it was also about carrying all of that, the voices, the stories, the lived realities of so many people from the Pacific, and trying our best to articulate that. It was a bit nerve-wracking. It was completely different space altogether. Space where you often feel it seemed very colonial at times, how the ICJ, the space seemed like it, very, very not 2025-ish, I guess. And so the space itself gave a different kind of, I guess, had a different kind of feeling to it. And the opportunity to say and to speak to the court, and deliver the responses and deliver the arguments that young people were talking about and wanting throughout this campaign was a huge honor. And when we got that chance, we worked so hard to kind of ensure that we covered as much as we could. We were able to rebut some of the harmful arguments that we had seen. And we came from that space of really speaking truth to power, because there was no agenda behind what we said. There was no other reason for what we said. It was only speaking the truth to the judges so they hear what young people are saying and what young people face. And so I guess that helped bring that speech home and helped it deliver with impact, I hope, with impact, into what it was. So really an opportunity that we didn't want to miss, and I think would remain as perhaps the highest honor I would have in my life.
The UNGA resolution requested that the ICJ issue an opinion on the following questions. First, what are countries legally required to do under the UN Charter, international human rights law, the Convention on the Law of the Sea, the Paris Agreement, and broader international law in relation to climate change for both present and future generations? And second, what are the legal consequences when countries do not meet their legal obligations and cause serious climate harm? These questions revolve around determining who should take responsibility for the climate crisis and for what actions, and they explored when these responsibilities began and what should be done for those who are suffering the most despite contributing the least to climate change. This case is significant because it goes beyond just planning for future climate actions or current ambitions. It also delves into the idea of historical responsibility, so looking back at how the crisis originated and identifying those who have contributed to it the most. This is crucial because it means that alongside present and future emissions, past emissions play a significant role as well. The damage already caused, the loss suffered, and the harm endured must be acknowledged and rectified. This involves not only stopping harmful practices, but also providing climate reparations, not as a form of charity, Vishal says, but as a legal obligation. During the hearings, countries voiced a collective acknowledgement of the undeniable impact of climate change spurred by human activities. Not even oil-rich nations like Saudi Arabia question that climate change is a real threat. And yet on fundamental questions on the real obligations of states and the ensuing responsibilities for mitigation and accountability, developing and developed countries were split. The US, the nation that has contributed the most to historical greenhouse gas emissions since the Industrial Revolution, argued against countries being legally obliged to combat the climate crisis. Vishal said the US statement was a disheartening attempt to evade its responsibilities as one of the world's largest polluters, displaying a blatant disregard for the pressing urgency of the climate crisis. Other major fossil fuel economies like Australia, China, and Saudi Arabia also argued against legal accountability that developing countries are pushing for.
Yeah, there was a huge division, I think. It was to some degree expected. I think we knew that big polluters, the fight that they've been bringing to the UNFCCC and the COP spaces, we had seen it, we were familiar with it, and it was precisely the reason why we were exploring an option at the ICJ. So we knew that large polluting countries, global north countries, many of them would come ready to counter or to launch an offensive. What mattered to us was displaying to the court this global South solidarity around the case. What you would notice is that even though there were divisions, these countries that were arguing on the counter were in the minority at the ICJ. This was a small group of countries versus the global majority coming to the ICJ to speak about all of these very progressive elements, very progressive legal arguments that can help push climate justice forward. And so the US, for example, our response to all of this, we were very disheartened. There were certain elements we did not anticipate. For example, there were arguments that the international law cannot deal with abstract risks and abstract persons. And that was very disheartening because at the core of our campaign was this idea of protecting future generations. And that was a direct attack at arguments saying that international law cannot protect future generations, which is an absolutely absurd idea. Again, what we saw from these countries was an attempt to kind of water down the proceedings as much as possible, evade their responsibility, which is what it was. It was also because the large majority of countries had showed up with such powerful arguments to talk about what state obligations exist, who are the ones that have been causing climate change. It became very apparent throughout the proceedings. And so this was an attempt by these countries to kind of distance themselves, engage in kind of very creative legal maneuverings to kind of distance themselves from all of these arguments. Very technical, very legal, again, missing out the reality of what all of this was about. As you said, about people that are battling life and death situations every day because of climate change.
Discussions also touched on the human rights dimension of climate change, spotlighting the disproportionate hardships endured by vulnerable groups like impoverished communities, climate refugees, women, and children. But the interpretation of existing international human rights frameworks in imposing duties for climate action remained a contentious issue in The Hague. Countries like the UK, Switzerland, Saudi Arabia, the US, and China rejected assertions that human rights treaties inherently mandate climate-related responsibilities.
It's to a degree, we call it very hypocritical of these countries who supposedly are champions for human rights, who say human rights, democracy, and the protection of people's rights is paramount. But when we come into spaces like this, where we talk about, okay, really now we're wanting human rights to apply to a problem that's global in nature, that is clearly affecting the rights of people, and these countries try to distance themselves. So quite hypocritical of some of these countries to say A and then in a different context say otherwise.
The ICJ recently announced that it will issue its advisory opinion on July 23rd, 6 years after Vishal was first confronted with the idea of taking the issue to the world's top court. He says he is hopeful that the court will understand the gravity of the situation and issue an opinion informed by the realities of people on the front lines of the climate crisis.
We remain optimistic from the get-go back in 2019, and since the early days, we've been pushing for two things to come out of this ICJ advisory opinion. One is the recognition that human rights has a role to play in this, and that climate action should be informed and guided by this. And so we remain adamant and optimistic that the ICJ's opinion will include this element. And the second is that the idea of future generations. We're very hopeful, and we're very interesting to see how the ICJ deals with this idea of future generations and the rights of future generations, and whether that right has developed in international law. There were also questions around legal consequences, which would be very interesting to see, particularly around existing discussions on loss and damage, climate reparations, etc. The ICJ really has an opportunity to shed light, open the very, very difficult doors around some of these topics, some of which are domestic courts and others, climate litigation cases are also dealing with. So really guidance on legal consequences and some form of understanding of how to navigate these spaces from the ICJ is going to be very helpful. We've always known that the end goal was never to get just the advisory opinion. It was one step to the process, but what we get from the advisory opinion is a tool to then use and utilize within existing spaces to drive climate action and drive climate justice forward. What we've been working on right now is a plan and thinking around how can we implement and operationalize the advisory opinion once it comes out. How can we bring it into spaces like the Paris Agreement, the UNFCCC, the Oceans Conference, the Human Rights Council, etc. All of these spaces, and how can we make it work through this advisory opinion? How can we drive systems change, for example, through an advisory opinion, tapping into the transformative power of this opinion to drive systems change across society, across the international and regional spaces as well. And so really trying to see how we can push greater absorption and implementation of the advisory opinion, and how the arguments of the ICJ how can we creatively look at avenues to address the injustice of climate change, whether that's relating to compensation and loss and damage, whether it's mitigating to ensure we meet the 1.5-degree target, and support that's needed for countries in adaptation, etc. All of these areas, along with the broader dynamics of injustice that's at play in many of the frontline countries and communities.
Stories like Vishal's are inspiring for so many of us. We are increasingly witnessing young individuals wholeheartedly embracing the urgency of the climate crisis, often sacrificing their youth to champion climate justice. Their passionate advocacy and unwavering commitment to holding major polluters accountable for their actions exemplifies a remarkable dedication to a just and sustainable future for everyone. So as our interview came to an end, I asked Vishal to leave us with a message to fellow activists working so that their actions today can sow the seeds of enduring change for generations to come.
I think what we have seen in the last couple of years, and certainly what our journey and what our work at the ICJ has shown, is that it is always possible for ordinary people to come together and do anything possible. I certainly hope the ICJ advisory opinion and our story is an inspiration to many others, because what we rely on after this advisory opinion is the power of the people to help move this forward. It's ultimately going to be this army of people that need to rise up in different areas and different avenues, using different avenues and different spaces to push for climate justice, whether you're in academia, whether you're a student, whether you're in policy space or a lawyer. We need to be moving at all of these levels to help address climate change. And and get closer to the goal of climate justice. So I think the ICJ advisory opinion helps all of us in moving in our own journeys, in our own activism, in our own way forward. But never be discouraged, never be disheartened. I think there were moments in our campaign where we ourselves found in spaces like that, because of how difficult situations got, how tiring it couldn't be at times. But continuing the fight, it is possible. And I think there is huge potential in the power of the people. So never doubt that, and keep going.
Thank you for listening, and see you next time.